The gladiatorial arena of the modern sporting field is synonymous with bone-crushing hits, constant contact, and spectacular feats of athleticism, all for the admiration of the adoring crowds. But a growing trend has started to develop in retired athletes, with mood swings, uncontrollable outbursts, and brain deterioration. The term CTE, or chronic traumatic encephalopathy, is a condition that has recently come to light, and athletes want answers to why the sporting codes have allowed this condition to go unnoticed for so long. On today's podcast, I'm joined by...
Hello, my name is Jade and I'm a tort lawyer specialist.
Hi, my name is Temeka and I'm a medical legal expert.
Hi, my name is Abigail and I'm a sports journalist investigating CTE.
And they're here to help us understand and better gauge how this new condition is going to affect sporting codes around the world. But firstly, Jade, could you better explain to us consent on the sporting field?
The principle of implied consent has been recognised by the courts that in some circumstances, a person will have given implied consent to a certain type of physical contact, such as being bumped in a public setting. The courts noted that forcible bodily contact was part of a game, but it did hold that there is a in which a player consents to.
But when players step onto the field, don't they know what they're getting themselves into?
An inherent risk is a risk of something occurring that cannot be avoided by the exercise of reasonable care and skill. In the sporting context, it would be reasonable, acceptable, and often an unavoidable risk that one would expect to encounter in a particular sport. It is common in sports civil suits for defendants to be absolved from liability when a defendant shows that the plaintiff knew of the risk and voluntarily chose to assume it. For instance, it was held that a club can be liable for nuisance only from the point in time that it knew or ought to have known of the nuisance.
So what has the court recommended?
The court determined that sporting boards did not owe a duty of care in circumstances where it lacked control over the rules in matches where the players were injured.
Can you explain to us what CTE is?
So, chronic traumatic encephalopathy, also known as CTE for short, is a brain condition that is caused by repetitive exposure to mild traumatic brain injuries, which may or may not be associated with concussions and other hits to the head. These injuries trigger brain tissue to deteriorate and develop abnormal protein known as tau. So it was originally found posthumous in boxers, but is recently becoming heavily frequent in a range of ex-contact sports players, like that of American and Australian footballers, for example, Aaron Hernandez. So Aaron was an American NFL player who was convicted and jailed for murder. His CTE diagnosis has been found to be one of the most worst and advanced cases of CTE, which is potentially linking his CTE to his erratic behaviours.
So is there a way athletes can be diagnosed with this earlier?
Unfortunately, at current, CTE can only be diagnosed in a post-mortem examination. However, there are telltale symptoms that could indicate signs of CTE in players, such associated with a range of neuropsychological problems. Domestically, in 2018, the Australian Sports Brain Bank, also known as ASBB, was established to support the study of CTE in Australia, with already more than 600 donation pledges from amateur to professional sports people. As the research team of ASBB puts it, in this first ASBB case series, a snapshot of neurodegeneration in Australian people who have participated in contact sports, CTE was the most frequent neuropathology.
But when we consider the legal implications of what CTE has done to the sporting field, have there been any groundbreaking cases that have changed this legal sphere as a result of this condition?
3 major class actions have emerged within only the last few years. At the time of recording, there are 2 separate class actions against the AFL, alleging that players are owed compensation by league insurers for their impaired ability to work and the impact of subsequent mental health problems on victims and their families. NRL players now have the ability to lodge a similar claim, with military lawyers currently investigating brain injuries in current and former participants. They argue that the injuries were reasonably preventable and that a duty of care was owed by the NRL's governing bodies. To succeed, litigants will need to overcome well-established defences such as voluntary assumption of risk and the precedent set out in McManus and the Newcastle Knights in 2021, which ruled that the risk of concussion-related damage, even to the extent of severe neurological impairment, was obvious.
So what has the court recommended?
On the 1st of December 2022, a federal Senate inquiry was opened into concussions and repeated head trauma in contact sports. So far, 16 submissions have been entered, with the most common recommendations for reform being the following: a publicly accessible national database for confirmed and suspected cases of head trauma, uniform guidelines for dealing with head injuries in sport that are monitored at a national level, compulsory education on concussion-related risks and identifying CTE symptoms, increasing financial support for research, treatment and prevention, although opinions differ on whether funding should come from clubs and insurers or the federal government, and finally, categorising sports people as employees under the Workers' Compensation Scheme. The Australian Institute of Health and Welfare suggests that imposing financial liability on clubs for the neurological care of their athletes before and after retirement. The report is due to be published on the 21st of June this year.
Surely with all this public media interest, there would be a system that we could rely on. However, in Australia there seems to not be one. Could you explain why?
International Concussion and Head Injury Research Foundation provides us with a basic framework to follow, but is not legislated in an implemented framework. The choice to return to play after a brain injury decisions they have firstly recovered from their injury and have the legal capacity to make an informed decision, been medically addressed by a professional, and been informed of all possible long-term risks in a language they can understand. However, the Research Foundation's findings and reports in the medical world have also brought up issues in the legal world about the issues of consent. With the combination of the new evidence and various judgments alluring to future legal issues and large media attention, it would be recommended to bring in legislation into New South Wales to regulate all contact sports at all levels. This would create a duty of care on clubs, but also provide a minimum requirement to mitigate the liability. This would include regulations on training, medical training for players and practitioners, education in the identification of symptoms, and even providing a definition or requirements of what is a concussion with a lower threshold to protect the players.
Thank you guys. That was very illuminating on the field of CTE and its implications in the legal sphere as well as the sporting world in general. But on next week's episode, we're going to be looking at elderly individuals and the implications that they might face as a result of taking the drug Viagra.